In an interview that you gave in 1988, you were asked about your thoughts about Judge Robert Bork's nomination, and you said, and I quote, "Judge Bork was one of the most outstanding nominees of this century," unquote. Many Americans do not share Judge Bork's narrow views about the Constitution, views that would undermine many of the rights that we now take for granted, Judge Alito. Judge Bork thought that Americans had no constitutional right to use contraception. Judge Bork thought minorities had no constitutional right to have their votes counted equally, saying that in guaranteeing one man, one vote, the court, quote, "stepped beyond its boundaries as an original matter," unquote. In 1981, Judge Bork called Roe versus Wade, quote, "an unconstitutional decision, serious and wholly unjustifiable usurpation of state legislative authority," unquote. In addition, he had an unreasonably broad view of executive power, claiming that a law requiring the president to obtain an order from a court before conducting surveillance in the United States and against U.S. citizens for foreign intelligence purposes was, quote, "a thoroughly bad idea and almost certainly unconstitutional." Can we assume from your admiration of Judge Bork that you agree with some of these statements, or at least that you support some of these beliefs if you were sitting on the Supreme Court?
Senator, when I made that statement in 1988, I was an appointee in the Reagan administration, and Judge Bork had been a nominee of the administration, and I had been a supporter of the nomination. And I don't think the statement goes beyond that. There are issues with respect to which I probably agree with Judge Bork, and there are a number of issues with which on which I disagree with him. And most of the things that you just mentioned are points on which I would disagree with him. I expressed my view about Griswold earlier this morning on the issue of reapportionment. As I sit here today in 2006, and I think that's what's most relevant, I think that the principle of one person, one vote is a fundamental part of our constitutional law, and I think it would be, I don't see any reason why it should be re-examined, and I don't know that anybody is asking for that to be done. Every legislative district in the country and every congressional district in the country has been reapportioned, has been redistricted numerous times in reliance on the principle of one person, one vote, and the old ways of organizing state legislatures have long been forgotten. So I think that's very well settled now in the constitutional law of our country. Under the Fourth Amendment, I have no question about the decision in United States versus United States District Court, which held, and I think that's what you were referring to, which held that a warrant is required for domestic security surveillance, and that was the decision that led to the enactment of the Foreign Intelligence Surveillance Act.